Hi there, Dom Garrett, Senior Correspondent for Vita News here with your THR update. As you can see, we are not in our normal studios. Due to coronavirus, we are taking the health and safety of our team incredibly seriously, so we are practicing distancing guidelines. We hope that all of you out there are staying healthy and safe as well, but the tobacco harm reduction news does not stop, so we're not going to stop giving it to you however we can. So let's jump right in. In a letter yesterday to the U.S. Court of Appeals, the FDA is asking for an extension on the deadline for the PMTA, or the Premarket Tobacco Applications. That deadline was originally set for May 12th of 2020, and they are asking for a 120-day extension. Now, the PMTA, if you're not familiar, it stands for the Premarket Tobacco Application. This was originally designed to give the FDA a way to take a look at any new tobacco products before they hit the shelves in the United States. Originally, it was set just for cigarette and smokeless tobacco, but as of May 2016, the FDA finalized what's called a deeming rule, stating that these guidelines are also to apply to vapor technology as well. Under this deeming, any product that is made after August of 2016 would have to file this application before the product can hit the shelves, but it also worked in retrospect. So any product that has been on the shelves needs to file this application. So why exactly is the FDA asking a judge to change an FDA rule? Well, back in 2016 when this was passed, the FDA set a deadline for companies to file the application, but for whatever reason, they pushed that deadline back a couple of times. Now, this made a lot of anti-vaping advocates pretty mad. So mad that they actually filed a lawsuit claiming that there was no time for public comment on those deadlines being pushed back. And they were hoping to force the FDA through this lawsuit to pull all of the products off the shelves until those applications were in process. Now, obviously, the industry and advocates for tobacco harm reduction fought on the other side. And after a judge heard both of them, he ruled basically right down in the middle. In October of 2019, he stated that it was true that comments should have been heard. However, he couldn't actually enforce those things immediately and set this May 12th deadline. And that's where we're at today, where the FDA said that due to the extenuating circumstances from the coronavirus outbreak, they would not be able to enforce that. And they were asking for that deadline to be pushed back 120 days. What does this mean for consumers? Well, technically nothing right now. It just means that this deadline could be pushed back. As of the recording of this video, the judge has not ruled on either side. However, we will be following the story very closely. So make sure to follow vita.news on all of your platforms, Twitter, Facebook, Instagram, on YouTube, and we will be sure to let you know what happens as soon as the judge reaches his decision. Thanks so much, and I look forward to talking to you again soon.